draw out, I suppose, some strands of argumentation rather than complete argumentation that emerges from my PhD research that tries to problematize homophobia-related violence, queer identity and politics in South Africa. And the research itself was really focused on a post-structural feminist and post-colonial reading of media texts, of policy texts, and of focus groups with lesbian-identified women. And very simply, what I was trying to do is to look at the ways in which homophobia-related violence both reveals and conceals things about race, about gender, about sexuality, about power in a post-colonial context. I'm going to start with what I'm going to try and broadly argue, and then I'll move backwards from there. What I'm trying to put forward, in a sense, here in a quick and dirty way, but in my forthcoming book in more detail, is a critical appraisal of law and the relationship with law and LGBTI subjectivity, or freedoms and unfreedoms. And my starting point is a recognition that law is both an instrument of freedom and an instrument of the denial of that freedom. What I'm also trying to suggest is that constitutional-driven legal protections and recognitions have in fact effected both a material and a symbolic shift for LGBTI people. So a shift from criminalization and invisibility that was very central to the workings of apartheid and colonialism and slavery, to a system of rights and recognition. However tenuous and however incomplete that may be, I want to suggest that there is a significant rupture from the past. And I also want to say that I think that as we as LGBTIQ people, as non-conforming gender and sexualities, as we increasingly place both our desires and our demands for freedom before the law and the state, it's critical for us to be thinking about how legal-juridical power both produces and perpetuates the very hierarchies of inequality that we're trying to, in a sense, undo, or at least some of us are trying to undo. I think others of us might be trying to reinforce them. And that those hierarchies are underpinned by violence. And here I'm theorizing violence as an instrument of power, various forms of power that both work with one another and against one another. And I'm making this argument today through three lenses. The first is the regulation or the regularization of queer sexualities and genders. The second is the production of queer injurability, or the injured queer. And the third is around hate crime. And all of these, of course, are constituted through law and through other forms of discourse and reality. A little bit about the context, and I think I'm going to move quite quickly here because I'm going to make a terrible presumption that legal scholars know something of the South African context. But maybe just to start by saying that my understanding of the colonial and the apartheid project is that it was a project of racing, of racializing people, of gendering people, and of heterosexualizing people. And so the colonial project was heavily invested in the notion of a particular form of Western sexuality and a particular form of African sexuality. And many people have spoken about that. And the effect of that is an erasure of sexual diversity and an erasure of gender nonconformity. So against that backdrop, I think that the advent of democracy and of constitutional democracy, as we all know, enshrined the right to equality and non-discrimination for LGBTI people, and that as a result of that, there were significant processes of law reform, there was significant strategic litigation that in effect shifted LGBTI people from what one might say the bad side to the good side of the law. So through a change in various laws, gay and lesbian people in particular were able to assert parenting rights, adoption rights, employee benefits, and ultimately marriage, for those of us who, for some weird reason, might want it. And I think, importantly, the advent of formal legal equality enabled the fuller participation of LGBTI people in public life and enabled LGBTI people to make social, political, and cultural claims using the leverages of democracy and constitutionalism. So we've seen law as a site of critical resistance to historical forms of oppression and their contemporary forms, and whether that's through using the courts or whether that's through some of the more recent mobilizations against violence, for example. I would argue that law has been an important site in which voice has been enabled, and of course law is used to in some senses, continue the silencing of non-normative sexualities and genders. Another important thing about context is, I think, what I've written about, this sort of marriage-murder paradox. The fact that queer life is benchmarked by both marriage on the one hand, the ability to in a sense be recognized by law, and murder on the other. So the continuous violent exclusion of people who disrupt a status quo. And obviously that paradox is linked to a set of historical conditions that I think are continuing into the contemporary moment. Really importantly, of course, is within LGBTI queer politics, there's a high level of contestation, right? So there are different positionalities, there are different forms of power that are playing themselves out within that politics, some of which I think is very productive. And we can talk about that later. So what does this mean for the regulation of sexuality and gender? Well, first, we all know that law is a powerful way in which gender and sexuality is hierarchized and regulated. So the minute you enter the gaze of law, right, you become a regulated sexual and gender subject. So that's the contradiction about the ways in which LGBTI sexualities are now recognized in law, and in that same moment, how law has its regulating effects. One of the ways I think we see this is how law has been constructed as a dominant narrative in which we understand LGBTI existence in a way, right? So in Africa we see how law is pitted as the problem, right? Laws that criminalize queer sexualities, and then the extension of that is law as solution, right? We need to change laws in order to enable LGBTI freedoms. And I think this raises a particular problematic, because I would argue that the gay subject of law is a subject of legal modernity, or modernity and its legal instruments. So in a way, you've seen how gay rights has become a signifier of Western modernity's claim on cultural superiority. It's become a sign of Western progress, right, to treat your gays well. And in that moment, of course, non-Western cultures are inferiorized. So it's this idea, normative notion that African identity is by definition homophobic. And I think that's very, very problematic. We also see it in Israel with pinkwashing discourses. So how gay identity is used actually to assert certain forms of Western dominance, or neo-colonialism, as some might say. The other thing about this regulation of sexuality and gender, and we've seen it here, and as Judith Butler uses this notion of landing the state's desire. At the moment you land the state's desire, certain forms of politics that uphold race, gender, status quos, often, again, they get reaffirmed, right? So what we see in the South African context is the privileging of monogamy, right? So the good gays are the ones that get married and have kids now. How whiteness in that moment is often valorized, right? So whiteness and middle classness is put forward as in a sense, the global gay. And at the same time, of course, within that, black queerness is problematized. And the effect of that is to erase difference within queer identity. So through this politics of assimilation, this normative politics, what we do is we start to erase the differentiations within LGBTIQ identity. So we try and erase the fact that race and class and gender plays itself out within those politics. So I want to give an example of how these homo-normalizing regulations, how these hierarchies within queer identities operate in relation to violence. So this is a conversation between two white middle-class lesbian-identified women. And Jane says, and I'll read it, depending on how one wants people to understand what it means to be a lesbian and to allow them to consider that it's not okay to attack a lesbian, they need to be able to relate to a lesbian. And when they see normality, a school run, people doing their shopping, then it almost doesn't give people the excuse to treat human beings differently. Then Sophie says, but how do they see normality if they're in the townships? Jane, well, that's another conversation altogether. That also has to do with the social infrastructure where government allows townships to remain isolated and, broken apart. I don't have an answer for you, you know. I'm not a poor black lesbian in a township, and I can't speak on behalf of them. But what I can say is that if somebody tries to put lesbians in a box and call them animals or monsters or crazy feminists, and they see a normal person who has children, who carries a job, a normal person who looks after their lives, it's very difficult to justify that kind of violence or aggression towards them. So through this rather frightening discourse of normality, Jane affirms being a consumer, having children, being productive, engaging in self-care, and these social positions are the positions that lesbians should aspire to. And her argument is effectively once they aspire to these positions, they'll be able to ward off violence. So these notions of normal are deeply racialized. And we see this in this construction of the poor black lesbian, who's positioned outside the sphere of normality, read acceptability, that Jane describes or inscribes. On the other hand, the unmarked, the unnamed white lesbian, who performs this aspirational normalcy, is on that very basis no longer a legitimate target for violence. So the extension of this logic is that those who don't conform to dominant class, race, and gendered norms and supremacies, and by definition come from broken apart places, are justifiably targeted for violence. So you can see the power at work, the race power and the gendering power at work in this kind of statement. I want to move very quickly on to queer injury. So we know that injury is we know that injury produces a set of terms for political mobilization. And we've seen it very powerfully in the student movements, notions and direct experiences of black suffering, of queer suffering, are points of mobilization. And out of that we've spawned very important and powerful identity-driven movements for both visibility and resistance. But I want to problematize this also because it's reliant on the production of subjects that are defined by their injurability. And sometimes what that does is it fails to transform the terms on which that injurability is made possible. So we naturalize the idea that queers are, in a sense, always already injured. And I want to look at how this operates, and importantly, how many queer people are resisting this idea of always already injured. And I quote, Tando, "The law helps you when you've already been violated. Like I first have to wait, and then after it happens, I'll be like, oh no, I didn't get this job because he found that I'm engaged to my fiancé who's a woman. So I feel like it's late, it becomes too late. If I need the Constitution to fight for what it means, I was actually in a situation probably where I was discriminated against, which for me, I feel like, wow, why should I wait to be raped or beaten or, weird comments said to me for me to be like, okay, I'll go to the teacher and say these things happened. It does happen, that sense that I can actually get some justice if it's possible. But I want people I don't want to even be in that situation in the first place where I feel unsafe. So basically, here what we see is that Tando is rejecting the notion that queer injury should be a precondition for gaining agency using the law. She opposes the idea that one has to first experience discrimination in order to claim rights, protection, and justice. And in doing so, she's rejecting the law's reliance on this presumption of injury as the basis for its protection, and the consignment of being queer to a status injury alone. I'm not sure I'm going to go into in any detail the hate crime construct, but it's one of the ways in law in which queer injury is normatively inscribed. And I think it's problematic in simple terms because it reduces prejudice to individual acts of hate that are the result of internalized attitudes and behaviors. And it totally dislocates how hate operates as a form of power. It in a sense, takes away or obscures how the social context in which some people are produced as subjects who are hated and other people are produced as haters. And I think, although hate crimes, and I'm implicated in I must now divulge, in advocacy around hate crime recognition, because partly what it allows is that it allows us to, in a sense, make appeals directly to the state for action. But I think it's a catch-22 in a sense, because what it does is it invisibilizes the complex set of relationships of inequality that produce these mad or bad people, right? And the ways in which in which hate operates. So in a sense, the hate crime construct individualizes both the structural and the historical dimensions of the multiple ways in which queers are facing violence and exclusion. And here I think it's important to recognize that queer subjectivity, as we know, is intersectional. So one is not only queer, one is also black, one is also and or middle class or poor, and all those identities in a sense shape different forms of vulnerabilities. And I think that's significant in terms of how we understand hate. So I'm not suggesting that acts of violence are devoid of psychological content. Rather, that the discourse of hate crime disarticulates or disconnects violence, including its psychic dimensions, from the social and historical conditions of its making. And in that moment, of course, then we erase the histories, the structures, and the conditions in which some people are always hated, right? And other people use violence to secure and enable their own power. So that's one of the issues I wanted to raise. And then in closing, how am I doing for time? Okay. Finally, I wanted to just invoke a quote from a very powerful performance artist called Linnell Moise, who's from Haiti. And she, in a very elaborate poem that I'll play for you now, says the following: "We who ache for your acceptance, we are not waiting for your laws." And I think this assertion reflects what I'm trying to foreground in this conversation, and that is that there's both a reliance on and a defiance of law that's at work in sexual politics. So law as constitutive and as performative is wielded in ways that both enable and constrain queer agency. But I think importantly, I would argue, queer lives always exceed the law and its claim over those lives. And I think on this point, and by way of closing, I wanted to very briefly, and it's only a minute and a half, share a poem by Linnell Moise from which this quote comes.
We alive, we children of God and truth, we harbingers of sexual salvation, we brave enough to love ourselves when Senegal is trying to kill us. We with warm, worn, wild tongues, we with long, wet, seeking fingers, we with broken, open hearts when Gambia warns he'll chop off our heads. We with hungry, deep, urgent kisses. We in stilettos pumping stonewall fists. We with genders bent to meet our souls when Falls City, Nebraska rapes us. We with groins that want to talk dirty. We with mouths that want to come clean. We with legs that want to outrun when Laramie, Wyoming crushes our skulls. We who ache for your acceptance. We are not waiting for your laws. We were on our way to the accountant when Brooklyn left our torn limbs in trash bags. We with wigs and bikes and pride. We with leather and lust and poems. We with sass and guts and homegirls when Newark stabbed us in our chests. We are loving all over the world. We are hated all over the world. We are buried all over the world. We are grieving all over the world. We are praying all over the world. We are dancing all over the world. We are laughing all over the world. We are living all over the world. We alive all over the world. We alive.